Welcome to part three of chapter six, Contracts, from the Legal and Ethical Environment of Business by Terence Lau and Lisa Johnson. This is Dr. J. Kent Gregory, and we will wrap up chapter six within the next few minutes. So, voidable contracts. So the following defenses are relevant if the contract is validly formed but voidable by a party. So some of these uh, reasons to void a contract are when people lack the mental ability to understand, meaning they lack the capacity. So, for example, and related to this, I should say, a minor can understand the terms of a contract, but they lack the legal capacity to be bound to it. And so they can disaffirm the contract if they wish. So that meaning this is the option by the minor to render the contract void. Um, Also, if the subject matter or terms of the contract are illegal, and then impossibility is a defense that can be used when performing the contract has become truly impossible. Economic duress, a defense to a contract that can be exercised when one party had no other reasonable alternative but to enter into a contract due to economic threat or pressure. So that is very key right there. So basically, the person was forced into it. Unconscionability is a defense used when the contract contains markedly unfair terms against the party with less bargaining power or even sophistication than the party who created the terms. And then undue influence can be used when one party ceases to be able to exercise his or her free will due to the superior power and influence exerted over that party by the other. So these are all essentially kind of three related issues that are related to that are tied together, I suppose, by the power of one party over the other. So statutes of fraud. So if the contracts required by by the statute of frauds are not in writing, that can be used as a defense to performance. If there's a dispute arising under the contract, that dispute will not be enforced because it violates the statute of frauds requirement for a writing. And then the statute of limitations can be raised by a defendant to argue that the complaint is being brought too late to do anything about. Statute of frauds continued, so a mistake is rarely a successful defense. But if parties to a contract truly make a mistake with respect to essential terms, they can use that as a defense. But again, that's rarely a successful defense. Misrepresentation, fraud, commercial impracticability. This is defense that can be used when fulfilling a contract has become extraordinarily difficult or unfair for one party. And force majeure is the unforeseen act of God that prevents one or both parties from fulfilling their obligations under the contract. And then frustration of purpose right here is when the contract has become essentially worthless to one party, though the event giving rise to that state was non-existent or unforeseeable or unknown to both parties when it was formed. And then there's also bankruptcy. So when a party files for bankruptcy, protection is required to pay a debt that was incurred before the bankruptcy was filed. Then that duty is suspended temporarily or permanently when the bankruptcy is filed through the court. So an automatic stay. This is an order by the court to stop all collection activities and prepetition debts owed by a debtor or in bankruptcy. And then bankruptcy is a defense to performance of contract for the debtors who filed for bankruptcy. This is a great flow chart that's contained in your book that I want you to be able to refer to and take a look at that shows the formation of contract, whether it's legal and valid. So, take a great look at this in your book. Just wanted to point that out. Um, so remedies. So remedies for breach of a contract. There are expectation damages, including compensatory, uh, such as the finding substitute goods at a higher price, or consequential damages, such as lost wages or lost products, can be recovered. Specific performance will be required under certain types of contracts. And then on breach, the injured party has a duty to mitigate his damage, his or her damage. So assignment and delegation, this is really key. So contract elements are important. And contracts are assignable and delegable by law. So assignment means the ability to transfer the rights conveyed by a contract to another party. And delegation is the ability to transfer duties imposed on a party by a contract to another party. So assignment and delegation. So restriction on assignment. Restriction on assignment, this is a clause that in a contract that prohibits parties from transferring the rights conveyed by contract to another party. The way to excuse oneself from this liability is to form a three-way novation with the original party and the new party, and thereby excusing the exiting party from future liability. So the novation is this agreement that transfers all rights and duties to a new party. So this could be, for example, when you, fire your realtor. This could be when you, have to get out of the lease of your apartment. Just some examples there. An exculpatory clause. This is an express limitation on potential or actual liability. And a non-compete clause, which we've talked about quite a bit or referred to quite a bit already, and we'll spend some time on in class. Other clauses, mandatory arbitration clause. This is a contractual clause, which we've referred to in a previous chapter, that requires the parties to a contract that contains such a clause to submit mandatory arbitration in the event of a dispute. Then there's the acceleration clause. This is a type of clause that accelerates all payments due under the contract at breach. And the liquidated damages clause. This is a type of clause that sets the amount of damages in the event of a breach. And then finally, to wrap this up, an assumption of a written contract. Major assumption about a written contract is that it is integrated, meaning it is whole. This is the legal assumption made about contracts, that they contain the entire expression of the parties' agreement. That means that it's assumed that they're integrated. And then parole evidence. These are statements or actions that are not captured within the four corners of the contract. So think of the contract as a piece of paper. The paper has four corners, and all of the writing, all the agreements, and the signature lines, and then the dates, are up there, all within the four corners. So statements or actions that are not captured in the contract are considered parole evidence, and they will not be used to interpret the meaning of the contract. So everything within these four corners, that is your contract. And that wraps up chapter 6.